Good morning, everyone, and welcome to this webinar, the subject of which is a year in review, legislative and judicial developments in 2020. My name's Thomas Williams, and I'm a partner of Sultan Al-Abdulla Partners, and I lead the arbitration team. I also represent clients before the Qatar International Court. We are very lucky to have four excellent speakers this morning, and I will shortly introduce them in the order in which they will present. They will each present for a quarter of an hour, 10 minutes, quarter of an hour, and after that there will then be a Q&A session for a further quarter of an hour. First up we have Jonathan Collier. Jonathan is a partner at Pinsent Masons and head of the Doha office. He specialises in contentious construction and engineering work and frequently represents clients in arbitrations in that sphere. Jonathan will be talking about the legal and contractual impact of recent labour reforms. He will be addressing the new minimum wage law and the abolition of the NOC requirement. Next up, we have Zain Sharaf. Zain is the senior legal counsel at the CEO's office at the Qatar International Court. Prior to that, he was the director of the Legal Affairs and Enforcement Department at the Qatar Financial Markets Authority. He's also worked at Qatar University as an assistant professor of commercial law and at the Legal and Judicial Studies Centre at the Qatari Ministry of Justice. Zain will present on the new QICDRC Mediation Rules. Next up we have William Catton. Will is the senior partner of SAP. He's a finance lawyer with a broad sector experience spanning banking, construction and oil and gas in the Middle East, Asia, the US and Europe. Will be talking about the challenges posed by the PPP law and also look at the effectiveness of the PPP structure in the context of major projects in Qatar. Last but not least, we have Andrew Woodward of Quantum Global Solutions. Andrew is the corporate and technical director and regional director here in Qatar of Quantum. He has particular experience and expertise within the construction dispute field and has provided contract, quantum delay and disruption advice to contractors on large-scale infrastructure projects in the Middle East and in Europe. He's also undertaken the role of party-appointed expert witness on matters of both quantum and delay. What Andrew will be looking at is the impact of COVID-19 and the recent labour reforms setting a minimum wage and abolishing the need for an NOC. He'll be looking at that from the practical perspective. So thank you all very, very much indeed. And I think it's now time for Jonathan to give his presentation. Jonathan.
Hello, good morning everyone. Thanks Thomas for that kind introduction. As you mentioned, the law that I'm going to mention briefly is law number 17 of 2020, and that law provides a guaranteed minimum wage for workers in the private sector. The law was gazetted in September last year, and as I understand it, there was a ministerial decision number 21 of 2020 on minimum wage, which stated that it will come into effect in March 2021. In March of this year. In that decision, the minister set the minimum wage at 1,000 Qatari riyals per month as a basic wage. It also stated that there'd be 500 Qatari riyals per month allocated for accommodation expenses and 300 Qatari riyals for food, unless the employer already provides adequate food or accommodation for the employee or domestic worker. So this law may have the effect of increasing costs to companies operating in Qatar, but they would not have occurred but for the law coming into effect. My area of specialism is construction law, and so I'm often asked to advise on main contracts between tier one contractors and their employer, which is typically a government entity, and or subcontracts between tier one contractors and their supply chain. So the impact of this law, it means that the contract should be reviewed to identify whether there are any adjustments or changes in law clauses included in those contracts, and analyse precisely what those clauses say. There's a standard in the industry which is the FIDIC Red Book, and that includes, and that's a form that we see frequently in the construction sector, and that includes a provision that states that the contract price shall be adjusted to take into account any increase or decrease in cost resulting from a change in the laws of the country, including the introduction of new laws. The change must have been published after the base date of the contract, and that provision goes on to say that if the contractor suffers delay and or incurs any increase in cost as a result of any change in laws, the contractor may be entitled to an extension of time and or payment, and it's subject to the claims regime being followed. So, and often the FIDIC Red Book provides notices having to be given in order to preserve and pursue those claims. That's the standard form position. In my experience, the standard forms are often amended, usually in the employer's favour. And of course, there are bespoke forms used by some of the larger procurers in Qatar, Ashcal being a good example of that. And so the key takeaway from this new law for me is that companies should analyse whether this minimum wage requirement that's going to come in March 2021 will have the effect of increasing costs of projects which they have entered into contracts to deliver, and therefore they should analyse carefully their adjustment in laws provisions to see whether it would give rise to any contractual claim entitlement. And the important thing also to bear in mind is to follow the contract procedures and processes, giving of notices to preserve those claims to ensure that they can maximise their recovery as a consequence of this new law coming into effect. So that's briefly what I wanted to mention about this new law and its effect and how it should be dealt with contractually. And so that's probably it from me. I'm happy to take any questions at the end. And so I'll now hand back to
Jonathan, thank you very much indeed for that. And as you say, we'll no doubt have some questions for you at the end. Zain, thank you very much.
Thank you very much, Thomas, for the kind introduction at the beginning. And I'm very pleased to participate in today's online event in order to talk about the Qatar International Court new mediation rules, which was issued last year. Before I address the rules briefly, I would like to give a quick overview about mediation and the importance of mediation as an effective method for dispute resolution. So basically, mediation is a process. It's a voluntary, flexible, and confidential process in which an independent third natural person assists the parties in their negotiation in order to reach a settlement agreement in respect of their dispute. Mediation is considered to be a quick and fast and effective way of dispute resolution. And also it is to be said that mediation has a forward-looking, that is mean that mediation maintain and preserve a future relationship between the parties, which will enable them to continue a working relationship in harmony in the future. Basically, mediation enable the parties to continue or sometime to begin their negotiations. The presence of the mediator in the negotiation process, it changed the dynamics of the negotiation taking part between the parties. And therefore, the mediator normally will utilize his skills to bridge the gap between the parties and assist them to overcome deadlocks, and he will be able to facilitate the communication between the parties in order to reach an agreed settlement agreement. Therefore, it's very highly recommended that lawyers educate their clients about the importance of mediation to resolve their future disputes, because even now mediation is subject to misunderstanding and misconception, which could lead to unnecessary objection to its use. So it's been said by many litigators and their clients that mediation is a bar to litigation or arbitration, and that's not quite right, because if the parties are unable to reach a settlement agreement in their mediation process, they can resort to litigation, or they may consider litigation or arbitration unless, of course, they agree otherwise. Also, many litigators, they see mediation as a compromise. And the word is compromise is not a word that is respected by many litigators and their clients. A compromise means settling the difference between the parties at the minimum, and that's not the case. It's very rare that mediation settle on these bases. Some people see mediation is a waste of time, particularly if the parties cannot reach into an agreement. And that's not correct as well, because the useful preparation for mediation is very useful also for the preparation of trial or hearing at the trial or hearing at arbitration or at the court proceedings. So as I said, mediation is a very effective tool, and lawyers have to educate their clients about its importance. Now, talking about the new Qatar International Court new mediation rules. So basically, these rules were issued last year. The rules set forth the procedures for the commencement of mediation, the appointment of mediator, how to conduct the mediation, and the conclusion of the mediation. So these rules, according to Article 1, shall be applied to mediation that is conducted in accordance with these rules. Of course, the parties can vary some of these rules with the agreement of the mediator. And according to Article number 3 of these mediation rules, the mediation can be initiated by the Qatar International Court or by the regulated tribunal with the agreement of the parties. Also, the mediation can be initiated by a written request by one of the parties in accordance, of course, with the mediation clause to refer the dispute to mediation. Also, mediation can be initiated by a written request by one of the parties and agreement of the other party, or without the objection of the other party. Generally speaking, if the court refer the case to mediation, then the court will nominate one of the mediator from the mediator approved list. Also, the court can basically nominate one of the judges who's been seeing the case as the mediator. Of course, if the settlement agreement cannot be reached, then that judge who's been acting as a mediator cannot sit on with the judicial panel to decide the case at a later stage. Also, if the matter is being referred to the mediation by the court. The court will notify the court registrar that the case before it is being stayed pending the outcome of the mediation. If the mediation being initiated by one of the parties, in this case, the court registrar will provide the parties with a nominated mediator. If the parties cannot agree on the arbitrator, then the registrar will make the appointment of the mediator. Of course, the mediator will have a complete flexibility how to conduct the mediation in such a manner as he consider appropriate, of course, in accordance with the case circumstances and the nature of the case. Generally speaking, the mediation will start by having a joint session between the mediator and the parties, where every party will have the opportunity to present his his opening statement. Then the mediator will have a private meeting with each party in the break room, and then it will be followed by a joint meeting by the mediator and the parties, so the parties can negotiate directly. According to Article 20 of the rules, the mediation will end if a settlement agreement is reached between the parties. Of course, this agreement must be in writing and signed by both parties. Also, the mediation will end if one of the party discloses clearly that he wants to end the mediation, or he's not interested to continue the mediation process. Also, the mediation will end if the mediator believes that there is no prospect to succeed in the mediation, or if the mediation is end by the mutual agreement of the party. Of course, the mediation process is very confidential. Anything that's being said or any document that's being presented in the mediation is confidential. That means it cannot be used in evidence in court, and all the documents are what we call without prejudice. That means that anything that's been disclosed in the mediation cannot be presented in evidence in court or in arbitration. The settlement agreement is confidential, of course, unless the parties agreed otherwise. So basically, the mediation is a very important tool. As I said, the liability of the mediator is being mentioned in the rules. So basically, the mediator will not be liable for any act or omission which is related to his mediation services, unless the act or omission is shown to be fraudulent or act in bad faith, of course. So basically, this is a quick overview about the mediation rules of the Qatar International Court. We encourage the lawyers to educate their clients about this important method to resolve the disputes, and also the Qatar International Court to provide its facility for free for the parties. So in order to encourage more parties to use mediation in their future dispute resolution. Thank you very much, Thomas.
Thank you very much indeed, Zain. It's over to Will now.
Thank you very much, Thomas. I'm addressing Qatar's public-private partnership law, which became effective in June of last year. At the risk of starting at too basic a level, if you want to build a big project, there are different ways to pay for it. You can pay cash, but that is not an efficient use of funds, and everyone, including the state of Qatar, has limited funds. So the preferred alternative is to borrow money. And typically, a project developer can contribute 20 to 30% of the cost of the project as equity and can borrow 70 to 80% of the cost of the project. Qatar has an excellent track record of financing billions of dollars of projects in this way. So for example, Qatar Petroleum and ExxonMobil create a company called Qatar Gas. The shareholders contribute 30% of the cost of the LNG facilities that will be constructed. They borrow 70%. During the loan period, Qatar Gas is paying principal and interest and making a small profit. After the loan is repaid, it's making lots of profit. Public-private partnership is just a different way to approach the financing and operation of a project. The classic example is a country wants to build a road between city A and city B. It grants a concession to a private company to build and operate the road and to charge a toll on the people who are using the road. The government spends no money and has no ongoing involvement in the project, and the private company takes the risk that enough people in city A and city B will want to use the road and will be willing to pay the toll. There are many variations on structuring PPP projects, and Qatar is taking a very different approach than the toll road model. The initial focus is on schools. The government is currently running a second tender now for a package of schools. The private company that is selected will build 14 schools that have to be ready for the school year starting in 2023. The private company will also be the facilities manager of the school for a 25-year period. Now, there are benefits that are not available in a traditional project financing structure. For example, projects can be refinanced after the construction phase is completed. Once a facility is built, the operation phase is less risky, and therefore it's possible to get cheaper finance. And so it is possible to refinance a project once the construction phase has been completed. Under the PPP structure, the benefits of a refinancing, the cost savings, are shared between the private entity and the government. In addition, after 25 years, ownership of the school facilities will be transferred to the government. So those are benefits. However, the government of Qatar is providing the cash flow. In Qatar, the government pays the tuition of Qataris who attend government schools. It may be that some of the students are foreign students who pay tuition, but fundamentally the transaction does not relieve any pressure on the finances of the government. In addition, two government entities remain deeply involved over the 25-year term of the transaction. Ashbel will be the supervisor of the private company during the construction and operation phases. So if there's a problem with the school, which undoubtedly there will be over a 25-year period, the private company will be sitting down with Ashbel officials to work out a reasonable plan to address the problem. I think it is fair to say that this is not what Ashbel normally is tasked with doing, and it will be a challenge for Ashbel. In addition, the Ministry of Education and Higher Education is responsible for what we might call the education side of the house. The ministry has to manage all of the school's administration and curriculum and has to appoint all the teaching and administrative staff. I have some experience dealing with the ministry. I was the chairman of the board at the American School, and I currently sit on the board of trustees of the DeBakey School for Health Sciences. And again, intending no insult, I think it is fair to say that this will be a substantial challenge for the Ministry of Education. Similarly, if a hospital project is implemented in Qatar using the PPP model, the Ministry of Health would be responsible for each hospital's administration and the appointment of all doctors, nurses, and administrative staff. So in summary, the Qatar approach does not achieve some of the classic goals of a PPP structure. It departs from a tried and true model for financing projects in Qatar and query if the benefits of the PPP structure justify departing from the tried and true model. And finally, it requires government ministries to undertake activities they have never undertaken before. And this last point, I think, is the most significant. Qatar has, of course, put a great deal of focus on selecting a private company that can implement the school's project. In my view, however, the success of the PPP initiative is more likely to depend on how the governmental entities perform their critical responsibilities under the PPP structure. Those are my remarks, and I would be happy to take questions later. Thank you.
Will, thank you very much for that. Now it's on to Andrew Woodward. Andrew, thank you.
Hi, Thomas. Thank you for that. I've got some slides as well, so I'm going to share a screen and put some slides up just to see if I can keep everybody interested. I hope everybody can see that. No, that's not the right screen, is it? Just bear with me a moment. Let me share that screen. I hope everybody can see that. And thank you again for the opportunity to talk to you today. I'm just going to give a brief presentation on some of the practical impacts that we're seeing on site construction sites from the legislation developments that are underway at the moment. Thomas gave me an introduction this morning, and as I say, I'm talking about the practical implications and effects that we're seeing on site. Before I talk about that, just to give some background, as a country, we've seen some significant infrastructure developments. We've got a lot of projects that are now complete, so most of the major highways are open, and we've seen a major shift towards the local roads and drainage programme. We're now seeing a lot of the stadiums opening. So really there's a push now towards the preparations for the World Cup, which is not very far away now. There's a move towards the development of the fan zones. There's what we call the entertainment plans being developed, issues with licensing. We've seen a lot of beautification of Doha, with parks and public spaces being improved. And again, that's part of a grand plan for the preparation for the influx of fans. And Lusail, we're now seeing a lot of heavy development in Lusail with the 4 main towers constructing, getting on now. We have the Commercial Avenue development, which is progressing well. And there's Katifan, the islands across from the towers, and there's the new water park that's being developed. I'm going to attempt to pronounce that. Perhaps what's not on the radar, but what we have seen is there's a lot of significant security developments been going on. We've seen a lot of investment in the country in air defence infrastructure. We've actually got 2 new airfields that are just about coming to completion. And a lot of this investment obviously developed from issues with the blockade, but also primarily again from the World Cup and the security commitments for the World Cup. So 3 air bases underway, 2 major runways now close to being open. So they're the home for the new Typhoon fleet. There's actually quite a lot of missile batteries around the country as well. And Ras Laffan, lots of talk now about plans for new investment and lots of talk on the horizon for the second gas train and future gas developments. So it's been a busy place, Qatar, for the last few years. But in terms of impacts and changes of the law or tightening the law, COVID and the travel restrictions has probably been the main thing that we've seen over the last year. What have the impacts been from that? Well, a lot of people have been telling me about how they've seen resource take flight and lost a lot of people in the March-April period, and certainly a reduction of resource being available within the country. And then obviously once you've lost some of your resource, companies have not been able to get the resource back, cannot bring the key staff back, or certainly restrictions on getting people into the country. And interestingly, restrictions on particular specialists not being available. And certainly some projects have had some major impacts from particular specialists who reside out of country, not being able to get into the country to do what they're required to do. And the obvious one is with the quarantine. If you do travel and you're based as a resident, to get back in the country, you've then got to go through the quarantine process. And arguably that can have a non-productive time impact of about 3% onto your project. Certainly sitting for a week or 2 weeks is not very productive for your staff. So a lot of issues with this. But there is some rule bending going on, and certainly some exceptions for particular strategic projects. So as usual, there's some slightly different rules for different people, but on the whole, a lot of companies are struggling to get key resources into the country at the moment. Second thing then is COVID workplace restrictions. What are the impacts from that? Well, certainly there's been a change to the management of resource and a push to be more segregated with the resource and keep people separated. So we see more implementation of more segregation of the worker communities, changes to the phasing of meals and meal processes, and also changes to busing and transportation arrangements. So certainly a lot of changes in the logistics of how you manage projects. There's also just a simple loss of work opportunities. COVID has introduced a lot of changes of behaviour in people. There's people going out doing less entertaining, so there's less entertainment. A lot of people have seen the maids go. There's less driving around, and certainly a lot of people sort of calming down on the amount of stuff that they were doing. So in terms of overall impacts, I think the impact on white collar workforce has been more nuanced. You know, I think that you might come across some people who are actually a bit better off after the year of the COVID restrictions, but certainly construction has been hit by a substantial reduction in workforce productivity, and a lot of my clients talk in terms of, you know, a 50% drop in productivity as not being unusual. Certainly entertainment industry substantially curtailed, and a lot of people staying at home for the foreseeable future. And obviously Qatar Airways and flights and tourism took a significant hit and a very big reduction in activity. A lot of the workforce have gone, and I hear that their flights are now returning, but they're only at around 50% of the level of what it was last year. Just then touching on to the change in the NOC rules and the minimum wage, and what are the impacts from this? Well, in terms of immediate impacts, legal requirements to raise wages is going to impact the lowest wage workforce, and that'll be bringing it up to a minimum standard. So that will impact certainly a lot of contractors with their labour force costs. And then with the NOC as well, you will see that there'll be a lot of people moving around. There's now not that restriction of people being tied to particular employers, but you start to see people moving around looking for the better pay. So companies losing more workforce, and that workforce becoming a bit more mobile. And again, I'm getting feedback from contractors that this may impact them in terms of 20% in direct cost of labour. I mean, in terms of a long-term impact, I mean, there's a cost burden now whilst the change is implemented, but in practice that should self-correct over time as contractors are securing new work and they build these impacts into their rates. So as new contracts come through, if there is any impact now, it should wash through over a period of time. But certainly there's a bit of a perfect storm at the moment with the resource scarcity and then the freedom to move around, that combining with the COVID restrictions, you know, is causing some immediate issues. And if you've got any projects that are underway at the moment that have fixed time deadlines, so if you're working on a World Cup stadium or you're developing parts of the airport or something that's got an immovable deadline, then this is going to have a real impact on you at the moment in terms of getting resources together to complete your jobs. So just to summarise for the year, what I would say is quarantine restrictions, okay, that might add 3% to your costs because you've got some people sat around for a week or two. That's just resource unproductive for a small period of time. The NOC, the minimum wage and COVID probably contributing to 20% on your labour. It's got the effects coming together in terms of combining the pressure to increase the costs on the lack of availability of the resource that you've got. And certainly time critical projects, they will be hit the worst at the moment. If you've got projects coupled with requirements to complete by a fixed deadline, for example, 2022, they're going to be under the greatest pressure. And certainly we've seen some companies reporting productivity being an issue and 50% drops in productivity over the last year. Looking ahead, we'll expect to see continuing pressure, certainly as we ramp up towards the World Cup, access to resource being a key issue. Beyond that, who knows? The pressure may be off in terms of the immediate World Cup tournament, but certainly at that point in time, I think everybody would be re-evaluating their own personal 10-year plans. So we'll see where we go from there. So that's my slides. Thank you very much. And then it's back to Thomas.
Thank you all very much. We don't seem to have any questions from the audience, but I had one question, if I may, for Zain about the mediation scheme. Zain, as you know, mediators can adopt one of two approaches at the invitation of the parties. They can either act as a mere facilitator, or they can take a more judgmental approach, and they can give an indication to the parties during the process as to what they think about each side's case. And some parties like one approach and some parties like the other. Has there been so far an inclination from parties under the court scheme to adopt one approach over the other?
Thank you very much, Thomas, for this question. Actually, the majority of the mediation that's been taken part in the Qatar International Court has been very successful. And generally speaking, as I said before, the mediator has a complete flexibility to conduct mediation in such a way in liaison with the parties. So really the court not prefer one approach to another and leave that to the mediator and the parties. Of course, there are matters that the parties and the mediator has to agree on, such as the venue, the dates, the time, are all matters of choice for discussion between the parties and mediator. However, the way the mediation is conducted, it's a matter for the mediator to choose the most appropriate way in accordance with the circumstances and nature of the case. So we haven't had any objection or any comments made by the parties in the style that's been adopted by the mediator. Of course, all the mediators that are approved in the mediator list of the court, they are very highly experienced mediator and has done many mediations. So I think in the current mediation rule scheme, we intentionally kept it very flexible in order to give the mediator much flexibility on how he see or what he considers best for the mediation to move forward, and in order to encourage the parties to develop creative options to resolve their disputes.
That's very helpful, but has the court seen a prevalence of the parties preferring one approach to the other?
No, we haven't seen any, no, the courts or the judges did not see that the parties prefer a certain approach over the other.
Yes, I see. That's very helpful. Jonathan, on the mediation point, you and I are contentious lawyers. It's our bread and butter work. Do you foresee that mediation will assume more of an importance in this jurisdiction?
That's a good question. I think mediation and possibly other alternative forms of dispute resolution have been talked about in Qatar for quite a long time now. And I think it's heading in the right direction. and take-up will. I personally think mediation is a good, is a useful tool for all the reasons that Dr. Zane pointed out. I think there's partly an educational piece around what litigants, if I can put it that way, understand about the mediation process and how it works. I think there's a degree of skepticism about it. I mean, I was personally involved in a QFT mediation about a year and a half ago. It was going back to your previous question, it was a facilitative process. The mediator, there was no intention for the mediator to deliver any sort of comment or judgment on either party's case. And we did actually reach a settlement, although unfortunately my opponent counterparty reneged on the settlement, so that we went straight back to court and had to resolve it that way. I do think it's a useful tool. I think it will gain some traction, but I think it's just a case of educating companies about what mediation is all about, how it works, and the benefits of it.
Yes, and of course, as you and I see often in arbitration agreements, you have to mediate as a condition to arbitration. And so often we need to have a conversation with the clients about what mediation is and what its benefits are, quite apart from the fact that they've got to go through it as a process. And so hopefully they don't just shrug their shoulders and say, well, we've got to go through it and it's a burden in terms of cost and time. But in fact, we might actually get some substantive benefit from it because the case might actually settle. A question for Will. Can William again tell us the key differences of PPP in Qatar as opposed to traditional PPP?
I think the main difference is the ongoing involvement of the project sponsors, if you want to put it that way, the governmental entities. This is a very significant departure from the way projects have been implemented in Qatar previously. There are smaller items like the sharing of the refinancing benefits if a refinancing can be implemented. But fundamentally, there's a third P in the name. It's the partnership. And the partnership means an ongoing involvement in the management of the projects by governmental entities. They are not used to doing that, performing that function. And typically, government entities will simply point to the contract and say, this is what the contract says. You either do it or not. And if you don't do it, we will impose penalties or potentially terminate the contract. And the way successful PPP projects have been implemented in other jurisdictions is in a much more of a partnership arrangement between the governmental entity and the private company, because undoubtedly issues arise and those issues need to be successfully managed other than through formal dispute resolution types of arrangements.
Will, thank you for that. Which is just in, which I'll read out. Are there any lessons we can learn from the way dispute resolution processes are set in the UAE? Speaking for myself, I'm not sure there are really. The setup in the UAE is pretty similar to the setup here. Arbitration's alive and well in the UAE as it's alive and well here. We have local court litigation, and we also have a specialist offshore court in the guise of the international court, just as the DIFC court has its court. So I think that the setup is pretty similar. I'm not sure that we can necessarily learn any lessons from the way that Dubai does things, although they have a respective arbitral and court setup just as we do. I don't know whether anybody else in the panel wants to comment on that.
I think it's an interesting question. I think that's right. Honestly, the only development in the UAE which I'm not sure I've seen here is the setup of a specific construction in the UAE and in the DIFC. With all of that said, I think certainly the international court and the bench on the international court would probably have a good degree of construction experience. I'm obviously talking about construction because that's my area, but and it's interesting talking to my colleagues in Dubai, the actual take-up of the IFC construction court, because it is an offshore court, so you have to contract into it, and so it has limited take-up. But I just thought that was an interesting development in the UAE.
Yes, anybody else want to comment on that question?
Yes, thanks, Thomas. Yeah, I totally agree with Jonathan. And just I wanted to add that in recent years, we have seen the popularity and rise of these specialized commercial courts in many countries, such as now Netherlands, China, France. And we see that international investors tend to prefer litigating in these specialized courts because it provides the benefits of arbitration. I mean, particularly if the decision of the court going to be enforced in the country. So the judges of these specialized court are very highly trained, and they have a huge experience in different types of cases: construction, financial services cases, technology cases. Also, the procedures and the process are very similar in common law countries. So the investors will feel that the rules of the courts are not new to them. Also, the most important thing is that the effectiveness of having a court decision which is much more easy to enforce in the jurisdiction in comparison to arbitration awards. So yes, there are lots of similarities between countries which have now these specialized commercial courts, whether in Singapore, Hong Kong, many other countries now, they start to consider even to create these courts in their jurisdiction.
Well, Zain, thank you very much. It's now 12:15. I think that we can call this webinar to a close. I want to thank everyone very much for attending. I want to extend special and particular thanks to each of our speakers for their excellent presentations. Thank you all very much indeed. If there are any further questions that people attending wish to send in, please do, and I can ensure that they're filtered to the correct panelist to answer. So again, thank you very much indeed, and goodbye.
Thank you.